In the thrilling world of yacht racing, the stakes are high, the competition fierce, and disputes inevitable. Picture this: the year is 1897, the air is thick with anticipation, and the waters of the Solent, off the coast of southern England, are about to bear witness to a monumental yacht race. A race that would not only rock the boating world, but also challenge the very core of contract law. At the heart of the storm were two men, Sir Richard Clarke and the Earl of Dunraven. Clarke, a seasoned sailor, and Dunraven, a nobleman with a taste for adventure. They were set to compete in a regatta, a series of yacht races under the banner of the famous New York Yacht Club. The rules were simple. Each man would enter his yacht, Clarke with his Satanita and Dunraven with his Genesta. The stakes? A hefty wager of £200 for each race, a sum not to be scoffed at in the late 19th century. But as fate would have it, Dunraven withdrew his yacht, leaving Clarke's Satanita to compete against other entrants. However, the plot thickens. Satanita, despite being the only horse in the race for the wager, met with an unfortunate accident. The damages were substantial, and Clarke, feeling the sting of the accident and the absence of his competitor, decided to seek compensation from Dunraven. With the crash of the gavel, Clarke v. Dunraven was brought before the court, a case that would go down in history as a landmark decision in contract law. The crux of the dispute was whether a contract existed between Clarke and Dunraven. After all, they had agreed to the wager. But was this agreement legally binding? The court was tasked with untangling this complex web of promises, obligations, and gentlemen's agreements. The decision hinged on a key principle of contract law: the intention to create legal relations. The court, in its wisdom, held that the wager between Clarke and Dunraven was more than a mere gentleman's agreement. It was, in fact, a legally binding contract. The Earl of Dunraven was held liable for the damages to Satanita, a decision that surely left a bitter taste in his noble mouth. Clarke v. Dunraven is not just a tale of a yacht race gone awry. It stands as a testament to the power of contract law, demonstrating that even in the realm of sports and wagers, the law holds sway. It reminds us that an agreement, whether made on parchment in a lawyer's office or on the deck of a yacht, carries weight. The implications of this case are far-reaching. It set a precedent for how the courts interpret contracts, confirming that the intention to create legal relations is a cornerstone of contract law. It also serves as a cautionary tale, reminding us all to tread carefully when entering into agreements, for the law is always watching. So the next time you find yourself in a wager, remember Clarke and Dunraven. Remember that a bet is more than just a handshake, it's a contract. And as we've learned, contracts are serious business. From the thrill of the yacht race to the solemnity of the courtroom, the saga of Clarke v. Dunraven is a tale of high-stakes legal battles and the enduring power of contract law. A tale that continues to resonate, more than a century later, reminding us all of the weight of our words and the law's unwavering gaze.